Now we have exclusively set up an arbitration center in our premises with the state-of-the-art facilities in Karmutu Center, just adjacent to our office premises. We have uploaded the rules and the infrastructure facilities in our website. If you want to know more about our services, please do feel free to be in touch with us. We are organizing this arbitration series under MAMC for the past 6 months. We've had experts addressing us on various aspects of institutional arbitration in India. This is the sixth in the series. The topic is advance on costs in arbitration, reimbursement of substituted payment. Once again, I welcome all of you to the session. And before I hand over to Mr. Thomas Williams, here is his brief profile. Mr. Thomas Williams is a partner dispute resolution arbitration, Sultan Al Abdullah and Partners, Qatar. Mr. Thomas is an English qualified barrister and leads the firm's arbitration practice. He's an experienced advocate in arbitrations and all the major institutional rules and ad hoc arbitrations, and has also appeared regularly as an advocate in the English High Court, including the Commercial Court and the Court of Appeal. He has particular experience of complex commercial disputes arising in the fields of energy, oil and gas, banking and financial services, and construction and engineering. Much of his work involves cross-jurisdictional issues and the conflict of laws, such as asset tracing and enforcement of judgments and arbitral awards. He has substantial experience in international cases and frequently works with overseas lawyers in common law and civil law jurisdiction. He is a graduate of Cambridge University and was called to the bar by Lincoln in 2002. We've had the privilege of listening to Mr. Thomas Williams when he began the session on India as an arbitration hub in April 2020. We are happy to have you here again, Mr. Williams. After your presentation, the Q&A session will be moderated by Ms. Madhuri, advocate and a member of our Legal and GST Committee. And I'm requesting Ms. Saraswati, Secretary General, to propose the vote of thanks. Over to you, Mr. Thomas Williams.
I would like to start by thanking Anirudh Krishnan for inviting me to deliver this lecture and the Madras Chamber of Commerce for organising this event. It's a great pleasure to be involved. I will be speaking today about the advance on costs in arbitration. When I talk of the advance on costs, I refer, of course, to the sum which a tribunal would assess as a suitable on-account payment to be borne in equal shares by the parties of the costs of the tribunal and or the institution in dealing with the proceedings. Specifically, I will be addressing the reimbursement of the advance on costs prior to the final award in circumstances where one party has paid on behalf of the non-paying counterparty and wants to recoup that payment from them. I have chosen this topic as the costs of arbitration proceedings are a very important factor for users of the arbitral process, and I expect that many such users are present today. Indeed, the relative cost of arbitration or litigation is usually a crucial factor when parties are choosing which dispute resolution method will govern their commercial relationships. Whether arbitration is in fact less expensive than litigation is a widely debated topic, but a common trend in arbitration that recently has emerged is the added financial burden on a claimant resulting from the refusal of a respondent to pay its share of the advance on costs. Such a refusal might well be caused by financial constraints, but it could also be a tactical decision aimed at deterring the claimant from pursuing its claims. In this situation, the claimant is likely to feel compelled to make a substituted payment on behalf of the respondent to keep the arbitration alive, and subsequently seek an award or order from the tribunal for the immediate reimbursement of those costs. I will discuss the position under the arbitration rules of the International Chamber of Commerce, or the ICC, the Qatar International Centre for Conciliation and Arbitration, or KICA, and other leading arbitral institutions. I would also explore whether the basis of a claimant's right to be reimbursed is contractual or procedural, and the consequences of that distinction for enforcement. Further, I will consider a recent partial award handed down in a Doha-seated ICC arbitration, which ordered the respondent to reimburse the claimant in respect of a substituted payment of the advance on costs. Under the ICC rules, the regime governing the costs of arbitration is set out in Articles 37 and 38 and Appendix 3. Article 37 prescribes the process by which the advance on costs is fixed. Article 38 governs the tribunal's decision as to the costs of arbitration. And Appendix 3 covers ancillary procedural matters and the rates at which the costs of arbitration are computed. Generally, the ICC court fixes a provisional advance on costs, which is intended to cover the likely administrative costs of the ICC Secretariat and the tribunal's fees until the terms of reference are drawn up. Thereafter, the ICC court decides the total advance on costs, referable to the aggregate quantum of the parties' claims and any counterclaims. As is commonplace under leading institutional arbitral rules, the parties are expected equally to share the advance on costs. While the ICC court has the power to fix separate advances on costs for claims and counterclaims, it only tends to do so if there is a significant difference in their quantum. Otherwise, a party bringing a considerably lower value claim or counterclaim would be unfairly burdened. Since the rule is that the parties are required equally to share the advance on costs, there is a risk that a respondent may fail to pay its share. Article 37(5) of the ICC rules, in that case, permits a party, normally the claimant or counterclaimant, to make a substituted payment on behalf of the defaulting party. However, the consequences for the defaulting party are not clear, as the ICC court does not appear to have the power to oblige a defaulting party to pay its share of the advance on costs. Notwithstanding this, under the ICC rules, if the advance on costs is not fully paid by the parties, the tribunal can suspend work, and the ICC court may consider the claims to be withdrawn. A defaulting party can therefore frustrate the process, so the claimant will have no choice but to make a substituted payment. I now turn to the KICA regime. Articles 43 to 48 of the KICA rules deal with arbitration costs. As with the ICC rules, the KICA rules also prescribe a non-refundable registration fee and empower the KICA Secretariat to fix the advance on costs referable to the quantum in dispute. The KICA rules go one step further than the ICC rules, however. Pursuant to Article 43.7 of the KICA rules, the case file is not transmitted by the KICA Secretariat to the tribunal if the arbitration costs are not paid. Further, under the KICA rules, a party is allowed to pay the defaulting party's share of the advance on costs, and, failing such payment, the arbitration may be suspended or terminated. Unlike in the ICC rules, there is no provision in the KICA rules which directs the tribunal not to proceed with adjudicating on a counterclaim, in respect of which the costs are not paid. However, as a matter of practice, KICA does not allow a counterclaim to proceed if the respondent has not paid its share of the arbitration costs. This ensures that the proceedings are efficiently conducted so as to avoid unnecessary delay and expenses that are likely to increase the costs of arbitration in an unjustified manner, as stated in Article 18.7 of the KICA rules. There are other institutional rules which deal expressly with substituted payment of the advance on costs. For example, Article 51(5) of the Arbitration Rules of the Stockholm Chamber of Commerce, or the SCC, envisage reimbursement of the substituted payment to the non-defaulting party. The SCC rules empower the tribunal to hand down a partial award for the reimbursement of the substituted payment of the advance on costs. The rules of the London Court of International Arbitration, or the LCIA, and the Singapore International Arbitration Centre, or SIAC, give the tribunal a discretion to order such reimbursement by way of a partial award or a procedural order. Articles 24.4 and 24.5 of the LCI rules entitle a claimant to recover the substituted payment as a debt from the defaulting respondent. Likewise, the SEAC rules at Article 27G authorize the tribunal to issue, open quotes, an order or award for the reimbursement of unpaid deposits towards the costs of the arbitration, close quotes. The rules of the Mumbai Centre for International Arbitration, or the MCIA, reflect the approach of the ICC and SEAC rules by allowing the institution to suspend or terminate its services if the advance of costs is not paid, whilst also following the LCIA rules in empowering a tribunal to hand down an award in respect of an unpaid advance on costs. If a party is compelled to make a substituted payment of the advance on costs on behalf of a defaulting party, the issue then arises as to the legal basis of the claim for reimbursement. According to Dewaze and Greenberg, writing in 2014, there are two opposing views. Either the obligation to pay the advance on costs is a substantive obligation between the parties, or a procedural obligation owed by the parties to the arbitral institution. If it is the former, the claim is a breach of contract, and the claim would be based on such. If the latter, the claim is brought for breach of a procedural obligation. I am of the view that the obligation to pay the advance on costs is a contractual obligation between the parties. Further to the arbitration agreement, the parties contractually agreed to comply with the applicable arbitral rules, including the obligation to pay their respective shares of the arbitral institution's advance on costs. Therefore, a respondent's failure to pay its share of those costs is a breach of the arbitration agreement. The sum paid by a claimant as a substituted payment of the advance on costs constitutes the claimant's loss. But for the respondent's breach of contract, the claimant would not have had to make the substituted payment. This view is supported by the writings of international arbitration practitioners and scholars. For example, Fadlallah, writing in 2003, states that, open quotes, the party's obligation under Article 37.2 of the ICC rules is not just an obligation towards the ICC court. It forms part of the arbitration agreement. The parties cannot agree to refer their dispute to arbitration and at the same time retain the freedom not to do whatever needs to be done to make arbitration possible, as they would then be in breach of their obligation to act in good faith, close quotes. Further, Matthew Seacombe asserts that, open quotes, the advance on costs fixed by the ICC court should be payable in equal shares by the claimant and the respondent, creates a binding contractual obligation between the parties. A number of order and awards have followed this approach. They were based on two elements. First, that Article 37.2 of the rules constitutes a contractual obligation between the parties. And second, that a dispute with regard to that contractual term falls within the scope of the arbitration clause in the contract between the parties, close quotes. In a similar vein, Derains and Schwartz, writing in 2005, say as follows, open quotes, there have been several instances in which ICC arbitrators, usually by partial or interim awards, have accepted to order parties to pay their shares of the ICC advance on costs. Such awards have been founded on the dual propositions that 1, Article 37.2 gives rise to a contractually binding obligation of the parties to pay the advance on costs in accordance with that provision. And second, a dispute between the parties with respect to a party's non-compliance with that provision falls within the scope of the parties' arbitration agreement, close quotes. Likewise, in 2000, Craig, Park and Paulson wrote that, open quotes, the defaulting party's refusal to pay its advance would ordinarily constitute a breach of contract, since by agreeing to arbitration under the ICC rules, it has agreed to respect its provisions regarding advance on costs, close quotes. Further, Fry, Greenberg and Mazur are of the view that, open quotes, the most common justification for ordering this kind of relief is that the parties have a contractual obligation under the ICC rules to effect payment. Failure to pay is, therefore, a breach of contract, close quotes. It seems to me that tribunals tend to follow this approach. For example, in ICC case number 13139 of 2004, the tribunal held that, open quotes, in the view of the arbitral tribunal, the agreement to arbitrate is a separate contract which differs in its nature from the contract on the merits, inasmuch as it is a contract of a procedural nature, but it is a contract nevertheless, giving rise to a procedural obligation to provide the advance on costs. The respondent accordingly had an obligation to make the advance, unless it is excused from this. As a matter of legal doctrine, the arbitral tribunal finds the conclusion inescapable that if a contractual obligation, even if it is a procedural contractual obligation, has been breached, it has jurisdiction to issue immediately a partial award in favour of the party that substituted itself for the defaulting party, close quotes. Likewise, in ICC case number 11330, the party concluded that, open quotes, the parties in arbitrations conducted under the ICC rules have a mutually binding obligation to pay the advance on costs as determined by the ICC court, based on 37.2 of the ICC rules, which by reference forms part of the parties' agreement to arbitrate under the rules, close quotes. In ICC case number 13290 of 2008, the tribunal noted that, open quotes, the claimant was effectively forced to pay the respondent's share of the advance on costs so that the arbitration would proceed, close quotes, and found that the amount paid by the claimant equated to the damage that it suffered as a result of the respondent's breach of contract. In ICC case number 15072 of 2008, the tribunal stated that Article 33 of the 1998 ICC rules did not only place a duty on each party to pay its half of the advance on cost to the ICC, but also expressed, open quotes, a contractual commitment of each party to the other to bear half of the advance on costs, close quotes. Similarly, in ICC case number 15506 of 2009, the tribunal held that the 1998 ICC rules were incorporated by reference in the contract through the adoption of the arbitration clause and were binding on the parties. Therefore, the parties were under an obligation to comply with Article 33 of the 1998 ICC rules to pay their respective share of the advance on costs. Reimbursement of substituted payments is more straightforward in arbitrations governed by arbitral rules which explicitly permit the tribunal to grant such relief. For this reason, LCIA tribunals are likely to render partial awards in this regard at the request of the non-defaulting party. Recently, a tribunal constituted under the arbitration rules of the Arbitral Institute of the Finland Chamber of Commerce followed this approach, saying as follows, open quotes, since the parties have adopted the FIA rules by reference to the arbitration clause, they have undertaken to comply with the obligation to pay half of the advance on costs. The prevailing doctrine affirms the contractual nature of such provision. The matter in dispute is thus a matter of substance on which the arbitral tribunal may render a decision regarding the reimbursement of the advance on costs paid on behalf of another party by way of a separate award, close quotes. However, a minority of practitioners, scholars, academics and tribunals take the view that the failure to pay by a party of its respective share of the advance on costs is a procedural matter which should be dealt with by way of a procedural order. For example, a tribunal in an ICC arbitration took the view that, open quotes, the agreement to arbitrate is a separate contract which differs in its nature from a contract on the merits, inasmuch as it is a contract of a procedural nature, but it is a contract nevertheless, giving rise to a procedural obligation to provide the advance on costs. Likewise, a tribunal in an arbitration conducted under the rules of the Vienna International Arbitration Centre, or VIAC, reached a similar decision. It held that, open quotes, according to the structure of the VIAC rules, fixing the costs of arbitration was a purely administrative matter. The arbitral tribunal, however, had to determine the costs of the parties and to state which party was to bear the costs of the proceedings, close quotes. By adopting the VIAC rules, the parties had agreed that the arbitration costs would be fixed by the Secretary-General, and this was by definition an administrative task. In the absence of any express agreement authorising the tribunal to order reimbursement of a substituted payment of the advance on costs, the tribunal could not overreach the powers granted to it by the VIAC rules. I understand that supporters of the alternative approach urge that a tribunal's role should be limited to deciding which party must ultimately bear the arbitration costs, and any issues arising from the non-payment of the advance on costs is solely a matter for the arbitral institution. In ICC arbitrations, a potential ground in support of this approach may be derived from Article 38.3 of the ICC rules. Article 38.3 provides, open quotes, at any time during the arbitral proceedings, the arbitral tribunal may make decisions on costs other than those to be fixed by the court and order payment, close quotes. It is therefore arguable that reading the ICC rules cost regime in totality, the tribunal is not empowered to make any decision relating to the administrative costs, which are fixed by the ICC court, and so must be considered a procedural issue. The tribunal's decisions must be limited to other costs, such as a party's legal costs in preparing or defending an interim application. On this basis, a tribunal cannot render a partial award ordering the immediate reimbursement of a substituted payment of the advance on costs, because the ICC rules do not explicitly set out such relief as a sanction for the non-payment of the advance on costs. However, I believe that such an argument is wrong. On the proper construction of the ICC rules, the purpose of Article 38.3 is to prevent the tribunal from deciding the quantum of the administrative costs, which is a power solely to be exercised by the ICC court, rather than depriving the tribunal of the power to order immediate reimbursement of the advance on costs. I would now like to consider the form of the tribunal's decision and issues relating to enforcement. The basis of the party's obligation to pay the advance on costs in turn dictates the form that a tribunal's decision should take, namely an award or a procedural order. This is significant because the form of the decision has implications for its enforceability. I believe that if a tribunal decides that the obligation to pay the advance on costs is a substantive obligation, its decision to order reimbursement should be by way of a partial award rather than procedural order. This view is consistent with the position generally adopted by tribunals. A partial award can, of course, be enforced under the New York Convention or any other applicable international treaty which recognises the enforcement of international arbitral awards. On the other hand, if a tribunal considers the matter to be merely procedural, it would likely order reimbursement by way of a procedural order. This approach will often present enforcement issues if the order is not satisfied. There are no international conventions or treaties that govern the recognition and enforcement of procedural orders, and enforcement must be pursued in accordance with the local arbitration and procedural laws. The arbitration laws of some countries, like Austria, Germany, and Switzerland, for example, allow the enforcement of foreign procedural orders. But other jurisdictions, such as England, only permit the enforcement of orders made by tribunals seated in England. In Qatar, the statutory regime provides for enforcement only of arbitral awards, according to Chapter 7 and Article 34.3 of the Qatari arbitration law. Therefore, in my view, procedural orders are not enforceable here. In order to avoid enforcement problems, a tribunal should be encouraged to order reimbursement by way of a partial award, provided it is satisfied that the obligation to pay the advance on costs is a substantive one. I would now like to look at an interesting case study in my jurisdiction. A Qatari party, the claimant, initiated an ICC arbitration against an Indian party, the respondent, for the recovery of outstanding payments due under a contract. The substantive law of the contract was Qatari law, and the seat of the arbitration was Doha, Qatar. During the course of the arbitration, the National Company Law Tribunal in India admitted the respondent into insolvency under the Indian Insolvency and Bankruptcy Code 2016, or the IBC. As a result of that order, insolvency proceedings against the respondent were commenced in India, leading to the suspension of its board of directors, appointment of an insolvency practitioner called a resolution professional to handle its affairs, and a moratorium was imposed under Section 14 of the IBC. The respondent failed to pay its share of the advance on costs, and the claimant made a substituted payment. The claimant then sought from the tribunal the reimbursement of its substituted payment of the advance on costs in the form of a partial award, or in the alternative, an interim measure by way of procedural order. In respect of its request for a partial award, the claimant sought the relief as damages for breach of contract, or alternatively, by way of specific performance under the Qatari Civil Code. The claimant contended that the parties had contractually agreed under the subcontracts to comply with the ICC rules, including the obligation equally to pay the advance on costs under Article 37(2). Therefore, the failure of the respondent to pay its advance on costs constituted a breach of contract. In support of this submission, the claimant relied on the writings of several international arbitration practitioners and the decisions of a number of ICC tribunals. In the alternative to seeking damages for breach of contract, the claimant sought specific performance by way of a partial award. For this relief, the claimant relied on Article 241(1) of the Qatari Civil Code, which provides that, open quotes, if the debtor does not execute his obligation voluntarily, he is compelled to do so, close quotes. Further, the claimant argued that the respondent owed a duty of good faith in respect of its contractual obligations, pursuant to Article 1721 of the Civil Code. Article 1721 provides, a contract must be executed in accordance with its contents and by a method that is in accord with the requirements of good faith, close quotes. The principle of good faith is a key civil law concept enshrined in many countries' civil codes. For example, the civil codes of the UAE, France, Germany, Switzerland, Italy, Greece, Portugal, and the Netherlands contain good faith provisions. The Quebec Civil Code of 1994 contains around 86 articles that contain the term good faith. Essentially, the claimant's case was that the respondent must not just honour the letter of the arbitration agreement, but also its spirit, in keeping with principles of honesty and fair dealing. Consistent with that duty of good faith, not only was the respondent required to pay its share of the advance on costs, it was also obliged to reimburse the claimant if it made that payment on its behalf. In the alternative to a partial award, the claimant applied for a provisional measure under Article 17 of the Qatari Arbitration Law, ordering the respondent to reimburse the substituted payment to the claimant. To meet the legal test prescribed in that article, which requires a risk to the applicant of, open quotes, irreparable harm, close quotes, the claimant relied on the respondent's insolvency in India. The claimant contended that under the IBC, the respondent faced two possible outcomes. Either an eligible buyer would submit a resolution plan, approved by the creditors, to buy the respondent and settle its debts, or there would be no such buyer or plan and the respondent would be liquidated. Although it was impossible to predict the outcome of the insolvency process, there was a definite risk that the respondent would enter into liquidation. If the respondent were liquidated, a final award in the claimant's favour would be nugatory. The respondent's secured financial creditors would receive priority over other unsecured creditors, such as the claimant. And given the respondent's total liabilities towards its secured creditors, it would be unlikely that the respondent would have any assets left for distribution to unsecured creditors for satisfaction of their claims. Relying on Seacombe's commentary and the decisions of other ICC tribunals, the tribunal held that, by referring to the ICC rules in the arbitration agreement, the parties agreed to be bound by those rules in a manner akin to any other contractual obligation. The tribunal disavowed the procedural approach, holding that the binding contractual force of the parties' obligation to pay the advance on costs could not be undermined by the fact that the ICC rules prescribe a procedural remedy in case of default. Accordingly, the tribunal held that the respondent's failure to pay its share of the advance on costs constituted a breach of contract and issued a partial award in the claimant's favour for the amount of the substituted payment. Personally, I think it is preferable for arbitration rules explicitly to authorize a tribunal to order immediate reimbursement of the substituted payment of the advance on costs. In this way, a non-defaulting party has a clear and effective remedy. Arbitral institutions whose rules do not make such provision should, in my view, consider revising their rules accordingly. However, in arbitrations governed by institutional rules which are silent on this issue, a non-defaulting party should seek reimbursement on the basis of a breach of the defaulting party's contractual obligation to pay its share of the advance on costs. The tribunal is likely to assume jurisdiction to decide claims arising out of non-payment of the advance on costs and render a partial award. Such an award should then be capable of enforcement under national arbitration laws and international conventions and treaties, including the New York Convention. Thank you very much.
Thank you very much, Mr. Williams. That was very comprehensive about it. I do have a question in the chat session, but before I actually ask the question, I have a question myself for you. One of the reasons that people look at into an alternate dispute resolution is the time factor and the cost factor. Now, if a party who has agreed to go into an arbitration process and actually steps back from not paying and puts an undue pressure on the claimant, do you think it's a setback on the whole system of the alternate dispute resolution itself?
Well, I think that it is, I think, potentially a fault, yes. And I think that eventually we've got to stand back from all of this and give tribunals the sort of power that courts have, which is to say, if you don't pay your fees, you can't have access to the dispute resolution process. I mean, why should it be that a claimant has to go to the trouble of stumping up the other side's share of the advance? I mean, that might put sometimes intolerable cash flow difficulties in the wake of a party. And it's just not fair if both parties have to stump up an equal amount at the start to get the process going. So yes, I think the time perhaps has come for institutions to say, okay, fine, this is a consensual method of dispute resolution. The parties have agreed by contract to this process, but that comes with the obligation to pay what you have to pay when you have to pay it. And if you don't pay it, then you don't get access to the process. And if that means that somebody's claim is heard without the other party taking part in the process, well, then so be it. But at least that defaulting party knows what it's getting itself into.
Yes, that actually makes sense. Yes, that makes a lot of sense. I have a question from Nilmani Gandhi. The question reads like this: as a procedural obligation of all the parties to the contract are bound to participate in the arbitration process. But if one party denies to participate and does not participate in the procedure, even though that party is given sufficient opportunity, can arbitrator be said that the tribunal's award needs to be set aside?
Not usually, no. I mean, provided that you've been given the opportunity to participate, it can't be said that there's been a failure of due process.
Okay, I hope, Gandhi, that answers your question. I have one more question that's by Soumya, but I'm not able to read it fully. Soumya, if you can type it and send it to me completely because it's just stopping halfway. I think while Soumya is on to it, let me just ask one more question, go and trouble you with one more question here. You gave an example of the parties going into bankruptcy or liquidation during the process itself. So now, what happens with the cost? I mean, would it be treated as a financial creditor or an operational creditor? How does that work? The
Well,
cost.
that's a question of Indian law that I'm not qualified to answer. But
Yeah.
certainly, if one party goes insolvent, then it can be extremely difficult for the party that isn't insolvent, because it knows that it's going into battle against a man of straw, or potentially a man of straw. And all you're left with, even if you win, is an award that is going to be treated very far down the food chain under unsecured creditors. Now, one of your remedies, of course, is to ask for security for costs and get a peremptory order in that respect, and see whether you can get the other side in a position whereby it can't have its counterclaim or even defence adjudicated on in default of non-payment. But it's a very tough order to get. It's extremely difficult to get security from tribunals. They just don't tend to order it, which might be considered unfair, but that's the standard practice. It's to refuse security for costs, even if the other side is insolvent. I mean, you might get an order for security if the other side has been squirreling away its resources to evade being held to account, to evade payment, to avoid having assets available for enforcement. But really, that's the only situation that I can see where you might be able to get an order for security. But it's very tough to demonstrate that.
Yeah.
And in most cases, people aren't engaged in that sort of behaviour. It's simply the case that you contract on one basis with a counterparty that's solvent, and then during the process they go bust. You've got no reason to apprehend that this was a possibility, and yet they go insolvent, and they might be defending and counterclaiming, and it might be that their counterclaim is basically the defence, but pleading a set-off. And in those circumstances, it's even more difficult to get security for costs, because tribunals will be reluctant to impede somebody from defending proceedings if they're unable financially to afford it. But it strikes me as very tough, because if the claimant wins, then it's not likely to get anything back from the respondent, including its costs. So yes, I'm afraid that if you're against an insolvent party, you often find yourself in a very tricky situation. And 9 times out of 10, 99.9 cases out of 100, you simply won't get any security from the tribunal to try to ameliorate that risk.
Yep, I actually got the question from Soumya. Is there any provision or jurisprudence to let the non-defaulting party to continue the arbitration without payment in substitution, and the cost of arbitration be recovered during enforcement of award against the defaulting party, maybe as a claim and priority?
That's a good question. I'm not aware of any, and I think that's unsurprising, because the advance on cost is an amount which the tribunal fixes to as a best guess estimate of what its likely costs are going to be paying the arbitrators, the tribunal's own costs of running the show on behalf of the parties. And frankly, if it's minus 50% of that sum, it's not going to be too happy. It's just not going to allow the proceedings to go forward in those circumstances. So really, the claimant wants to pursue its claims. The claimant knows that the institution isn't going to allow it to proceed with its claims in the absence of that payment. So it just has to be paid. I can't see an institution ever allowing a process to continue in the absence of the full payment, because that's the money which it thinks is needed in order to cover its bases.
Yeah, that's right. That's right. Yeah, I have one more question from Jnana Deepika. Can we refer articles or provisions of an institutional arbitrational rules in case of an ad hoc arbitration? Does it have a persuasive effect?
It would depend. It would depend on what rules you're using to run your ad hoc arbitration. What some people do is perfectly possible to have an ad hoc arbitration, but under the rules of a particular institution. Now, if you do that, then absolutely. I mean, you have the full gamut of the rules which you can use and related jurisprudence. If you haven't got rules to govern the process, then you're just left with the curial law, usually the main arbitration statute, which sets out what the procedure is going to be, and any soft law that you might adopt, and of course anything that the tribunal puts in place by way of usually procedural order number 1. If you can see that there are analogies between the rules which are in force under the curial law or anything that the tribunal has seen fit to impose, and any decisions or writings on cognate arbitral rules, well then yes, you can certainly refer to them as being persuasive.
I think the earlier first question of Soumya, she has a continuing question on that. She says her question was more in the line was, is there whether the cost can be recovered from the defaulting party by the tribunal itself, like our institution as a claim in priority.
So I say that again. Could the costs
be recovered from the defaulting party by the tribunal itself, or the institution, like the institution itself can recover the cost from the defaulting party as a claim in priority?
Well, if the tribunal or the institution, if the institution thinks that it's a contractual obligation that is owed to it, well then yes, it could do that. But I just don't think that it is a contractual obligation that's owed to the institution. I think it's a contractual obligation owed as between the parties.
So there's no jurisprudence on that. It's more of a contract. I doubt it if that's going to be a clause that's going to be inserted. Many would not prefer that kind of an institution to actually go into arbitration, is what I would think.
Yeah, I mean, it wouldn't be too good, I don't think, for institutions to start suing people that use their services. I mean, politically, I don't think that'd be very savvy. But on the legal question of whether or not there's a cause of action, that would depend entirely on whether it is thought that there is a contract between the institution and the parties, further to which the parties agree to pay the institution's costs. I don't think that's the correct analysis. I think that the correct analysis is that there is a contract between the parties for payment of the advance on costs on an equal basis, and that seems to be the way that it is approached by tribunals.
Okay. I have one question from Mr. Sendil Kumar and Krish. He asks us, could we bypass the arbitration proceedings and approach the court for the dispute? I'm assuming it's the fact that the advance on cost has been paid by one of the parties. We just bypass the arbitration proceedings and approach the court.
What you mean? If the in what circumstances?
I'm assuming that this question is more on the ground that if the advance on cost is not being paid by one party, so they just close the arbitration proceedings and go to the court.
Well, no, because you've agreed to arbitrate your disputes.
Yeah, that's right.
So the court would have no jurisdiction.
Yeah. Okay, so I have I hope you do have time for one more question.
I've got time for lots of questions. It's a pleasure.
That's nice. So assume a situation like this. There is an arbitration going on. The process has started. The first round of advance on cost has been remitted by both the parties, and the arbitration is going on. And then the arbitrator or the arbitral tribunal feels that they have to pay some more of the cost or additional cost. So one party agrees to it, but the other party does not agree to it simply because the arbitrator is unduly taking some time in conducting the proceedings. So in that situation, at that point of time, can the arbitrator, still push the government to go ahead and pay the cost or to pay in advance, or what would be the situation be treated like?
Yes, under the ICC rules, I think under most institutional rules, the tribunal can, or the institution more accurately, has the power to seek a top-up of the advance on costs if it feels that the initial advance was unrealistic. And as you say, that is invariably a function of the lifespan of the hearing, of the process rather, and that might come about through the fact that there are lots of interlocutory applications that weren't foreseen, or whatever it might be, or maybe one of the parties is ill, or I don't know what the reasons would be, but essentially, if the proceedings are going on for longer than anticipated, and the tribunal is more involved as a result, then there will need to be further costs paid on account by the parties. Now, invariably, such an order would be made on the basis that each party has to pay 50%. And I'm sure that in those circumstances, if the other side didn't pay, you'd make a substituted payment, the proceedings would go on, and you'd be making an application for a partial award to be reimbursed the 50% that you paid. So it would be on that basis. I mean, if you felt that the only reason why a top-up of the advance on costs, an increase of the advance on costs, was because of arbitrator misconduct, well, then you'd make your representations to the institution and try to convince them that, in fact, any cost should not be borne by the parties, but should be, in effect, borne by the tribunal or by the institution as the governing body. And you'd hope to find some sort of resolution that way.
Okay. I have another question from Mr. Pradeep. Can the arbitrator move the court to have the cost paid by the respondent until such time can he exercise lien on the award?
I think that'd be most unusual. I don't know whether that could happen in India, and I'd be interested in your view on that. No, I mean your remedies are from the tribunal first and foremost, and you have to seek these remedies first from the court, from the tribunal. You get the award from the tribunal reimbursing you, or whatever relief you need to protect your interests.
Mm-hmm. I think okay. So I think we have actually quite very well covered all the points here. I would like to hand over the proceedings to Saraswati, please.
Thank you, Madhuri. Thank you, Mr. Williams. It was an excellent presentation. I don't know whether we still have Ms. Pushya Sitaraman, the senior advocate, with us. Madhu, if she wants to specifically ask anything. Madam, are you there?
Mr. Williams, I was just wondering where there is a hefty counterclaim and the respondent refuses to pay his share of the advance on costs. Is it possible to just say that the claim will be heard and not the counterclaim?
Absolutely, yes. So we had this recently, whereby the other side didn't specify in their response to the request for arbitration that they were bringing a counterclaim, and that was probably tactical because they didn't want to pay more at that stage by way of their share of the advance on costs. We ended up actually making a substituted payment. Then they pulled a counterclaim out of the hat, which was a very, very chunky counterclaim. I mean, tens of millions. The arbitral institution didn't spot that the advance on costs was levied without taking into account the counterclaim, because it had neither been foreshadowed in the response or otherwise. And so we wrote to the institution and said, look, the advance on costs needs to be revisited because this respondent has not only failed to pay its share of the advance on costs, but it's now putting in a counterclaim. It's now filing a counterclaim, not having paid a penny towards the cost of these proceedings. It hasn't paid anything, even though it's availing itself as a counterclaimant of the process. And this just isn't right. And the institution agreed with us, and it directed that the counterclaiming respondent should pay a certain amount of money, several $1,000s. I mean, $50,000 US, and as a condition of having its counterclaim adjudicated upon. So yeah, and if it hadn't paid that amount, then the proceedings would have proceeded on the footing that they could defend our claim, but they couldn't bring their counterclaim.
No, I was really talking about a situation where the costs have been worked out, including the counterclaim, but only substituted payment has been made, and he is not willing to reimburse either. At that point, can an action be taken by the arbitral tribunal saying, since you have neither paid upfront nor have you reimbursed, I will not take your counterclaim on board? Is that possible?
Yes, absolutely. What you would say is, look, you haven't paid what you should have paid, and therefore I'm not going to adjudicate on your counterclaim. Absolutely. And any decent tribunal should accept that application. Otherwise, it's an abusive process. The claim, the defaulting party is riding on the coattails of the non-defaulting claimant. It hasn't paid a penny. For the privilege, and that isn't right. That's an abuse, and the tribunal should decline to entertain the counterclaim until such time as the reimbursement, which has been directed, has actually been satisfied.
Thank you.
Oh, that's really great, madam. And Mr. Williams, a very special thanks to you. For a lay person like me, I'm the Secretary General of the Madras Chamber, not a lawyer by any means. And these kind of topics, I was thinking when we had decided about this topic, probably I was thinking I wouldn't be able to understand anything on that. Such a complex topic, I made it so simple, very straightforward, very easy to understand, and very candid. And the way you handled the questions were really appreciable. Thank you so very much for spending your time and being with us, because these kind of programs we have been doing, as the registrar said, for the last 6 months, mainly to educate ourselves, understand topics at greater length on these things as this ADR, the alternate dispute resolutions, or gaining momentum here. Thank you so very much for being with us.
Not at all. Thank you all very, very much. I love India very much. I spent a huge amount of time in Chennai working with Anirudh Krishnan. It's a place that is Chennai is a place that is very close to my heart, and it's great to be involved in anything that will help Chennai and the people that work there.
Wonderful. That's really great to hear that. Thank you so much. And that probably leads me to thank Mr. Anirudh profusely for making this event happen, and bringing you to us here. I don't think he's able to join. He was held up in the court, but a big thanks to him. And I should thank specifically Madhuri for your wonderful moderations of the Q&A, yourself asking the questions and then moderating a lot and making the whole program very interactive. A special thanks to Prishya Sitaraman. It's a pleasure, madam, to have you with us, such a senior person, and we would be very happy to seek your guidance, help always. Thank you.
Thank you so much.
Thanks to Registrar, Ms. Madhumati, my colleague, and all the participants who joined this session today. Thank you so much. Stay safe.
Thank you.
Good evening.
Good evening.
Thank you. Thank you.